Hello, my name is Kendra Thompson, and this is my keynote presentation on New York Times Company versus Sullivan and Gertz versus Welch. Part 1, New York Times Company versus Sullivan. Who are the parties to the case, and what facts led to their dispute? The parties of the case are elected official of Montgomery, Sullivan, sued in the state court alleging that he had been libeled by an advertisement in the New York Times, the text of which appeared over the names of the four individual petitioners and many others. The advertisement includes statements, some of which were false, about police actions allegedly directed against students who participated in a civil rights demonstration and against a leader of the civil rights movement. Respondent claimed the statements referred to him because his duties included supervision of the police department. Why did Sullivan feel his reputation was damaged by the New York Times publication? Sullivan felt his reputation had been affected by statements that reflect upon the agency of which he is in charge. Although the Montgomery Public Safety Commissioner L.B. Sullivan was not named in the advertisement, the inaccurate criticism of actions by the police was considered defamatory to Sullivan as well due to his duty to supervise the police department. What must a plaintiff show to prove defamation, libel? The actual malice standard requires that the plaintiff in a defamation or libel case prove that the publisher of the statement in question knew that the statement was false or acted in reckless disregard of its truth or falsity. Because of the extremely high burden of proof on the plaintiff and the difficulty of proving a defendant's knowledge and intentions, such as cases when they involve public figures rarely prevail, they would have to prove actual malice, that the statement was made with knowledge of its falsity, and with reckless disregard of whether it was true or false. What was the U.S. Supreme Court's decision, and why did they make that decision? The court ruled for the Times 9-0. The rule of law applied by Alabama courts was found constitutionally deficient for failure to provide safeguards for freedom of speech and of the press as required by the First and 14th Amendment. The decision further held that even with proper safeguards, the evidence presented in this case was insufficient to support a judgment for Sullivan. In sum, the court ruled that the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials except when statements are made with actual malice, with knowledge that they are false or in reckless regard of their truth or falsity. Part 2, Gertz versus Welch. The parties to the case are lawyer Elmer Gertz and Robert Welch of the John Birch Society. The petitioner, Elmer Gertz, is a private person. The alleged defamatory statements about Gertz in the American Opinion article claimed he'd orchestrated Nucio's conviction and that he was a member of various communist organizations. The article further along talked about Gertz's lengthy criminal record, which included communist activity. Welch admitted to not thoroughly examining the accusations against Gertz. Therefore, not much was done to confirm the accuracy of the allegations at hand. I believe that the allegations affected Gertz's reputation as a lawyer, for the fact that now people who may have hired him in the past will consider and wonder if he's actually trying to win their case. I believe that being tied to communism also affected his future potential career advancements. To avoid the lawsuit, if I were Welch, I would have taken it upon myself to make sure the accusations against Gertz were indeed true. In Georgia, the elements of defamation are a false claim about the plaintiff, communication of the statement to a third party in the absence of a special privilege to do so, fault of the defendant amounting at least to negligence and harm to the plaintiff, unless the statement amounts to per se defamation. See Smith v. Stewart. These elements of defamation claim in Georgia similar to the elements listed in the general defamation law section. How can you relate what you've learned from the Sullivan-Gertz cases to your future work in the communications industry? Well, in regards to both cases, I will indeed make sure each and every accusation I make are backed with the truth and facts. As we know, the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials, except when statements are made with actual malice. Just knowing the difference between personal as well as public figures, and the line you can and can't cross regarding each person's will definitely be something that I take with me in my future communications industry. I'll learn what type of statements indeed are punishable by law. That way I'll never end up on the wrong side of libel. And I definitely will just take both what Sullivan and Gertz were able to learn, whether it being learning that it's not libel, or learning that it is libel, or whether you win or whether you lose, just knowing on what grounds you have to indeed make a claim against someone for libel will definitely be something that I take with me and I continue to use in both the present and the future.